Mr. Mayor, we're live.
Thank you very much, Madam Clerk. I'd like to welcome everybody in chamber and viewing from home the council meeting of Wednesday, February 12th, 2025. I'll call the reading of the land acknowledgement just after. I want to go through a couple of house cleaning matters. One is members, when you come to the mic to speak during open forum, and councillors, when you speak directly in the mic so everyone can clearly hear us at home. Anyone in chamber, please silence your phone during the meeting. And we'll call the meeting to order with starting with the land acknowledgement. The Township of Oro-Medonte acknowledges that we are situated on the traditional land of the Anishinaabe people and ancestral territory of the Huron-Wendat. The Anishinaabe include the Odawa, the Ojibwa, and the Potawatomi nations, collectively known as the Three Fires Confederacy. It continues today as the home for diverse Indigenous peoples, including the historic Métis community in Penetangwishing. The Anishinaabe people continue to have an enduring relationship with this land, specifically the Chippewas of Rama First Nations, the Chippewa Tri-Council, and the Williams Treaty First Nations. The Huron-Wendat nations also continues to pay respect and protect their ancestors and heritage on this land. We honor the Indigenous history and culture that have thrived for millennia in this territory and the treaties that bind us together as partners in the spirit of a shared and sustainable and prosperous future. We are all treaty people. Our commitment begins with acknowledging the truth so that we can move forward together towards reconciliation. Miigwech. May we have a motion to adopt the agenda, Madam Clerk?
Moved by Young, seconded by Shell. Be it resolved that the agenda for the council meeting of Wednesday, February 12th, 2025 be received and adopted as amended to withdraw item 18C, and that item 18D, minutes of closed session council meeting held on January 22nd, 2025, be brought forward to the next regular closed session meeting of council. And that item 15A, file 3050, be updated with correspondence and a revised report dated February 12th, 2025.
Thank you very much, Madam Clerk. I'll call the vote. All in favor? Opposed? Seeing none. May we have a motion to go past 4 hours if necessary, please?
Moved by Lavoie, seconded by Clark. Be it resolved that Rule 14.20A, as per the procedural bylaw number 2023-043, be suspended in order to allow the meeting to proceed past the 4-hour adjournment requirement if necessary.
Thank you very much. I'll call the vote. All in favor? And that is carried. Is there anyone, council members, that have a pecuniary interest to declare at this time? Seeing none, if you find you're in a situation where you have a conflict or pecuniary interest, please let us know at that time. May we have a draft motion for the 4 sets of minutes, Madam Clerk?
Moved by Hutchison, seconded by Lavoie. Be it resolved that the draft minutes of Heritage Committee meeting held on Monday, January 20, 2025 be received, and that the recommendation therein, per motion number HC 250120-4, be adopted. That the draft minutes of council meeting held on Wednesday, January 22nd, 2025 be received and adopted as printed and circulated, and that the draft minutes of the Human Resources Committee meeting held on Wednesday, January 29th, 2025, and minutes of Joint Accessibility Advisory Committee meeting held on Tuesday, January 21st, 2025 be received.
Thank you very much. I just want to make a note that there's a recommendation in the Heritage Committee minutes to authorize the designation of Carly Community Hall, and the draft bylaw is to consider later in today's meeting. Okay. Is there any other amendments or changes to the minutes? Seeing none, I'll call the vote. All in favor? Opposed? That is carried. There are no recognitions and achievements and introductions today, and no public meetings, and there's no deputations presentations. Is there any items that need to be moved up? I think there's not an array of a lot of things on the agenda today, so I don't take it nobody needs anything moved up on the agenda. Seeing none, we're at open forum. Madam Clerk, is anyone registered to speak at open forum?
No, Mr. Mayor, we do not have any registrations.
Okay. No one in chamber does anyone need to speak to any items on open forum today? Okay, no, seeing none. So we will move on. We have Mr. Ewert is attending today's meeting to give 3 reports out from IC issues. So before we get into it, I would like to explain kind of the rules of engagement during the IC reports coming out. The IC will be reporting out on 3 individual matters today. Each matter will be dealt with individually and separately. Once Mr. Ewert has concluded his report, all questions are to be directed through the chair to the IC. Okay, once all questions are answered, we will move forward to the next report. So I just want to be clear that we can't be jumping back to a previous report or bringing them in tandem. They're all to be dealt with individually. If an individual or the complainee wishes to identify themselves, only then can questions be directed through the chair to the complainee, okay? And I want to remind members of council that our questions and comments are to be professional and respectful and pertain only to the material within the report. Okay, so kind of laying that out, I want to welcome Mr. Ewert. And Mr. Ewert, whenever you're ready, you can proceed.
Thank you, Your Worship and Council, and thank you for having me this afternoon. I seem to be having a problem with my camera. Are you able to see me as I'm not able to see Council?
I can see your name, but I can't see you. Madam Clerk, is there any way of us fixing that issue?
There.
Oh, there you are, sir.
There we are. Thank you, Your Worship, and thank you to Clerk. Again, good afternoon to Council and yourself, Your Worship. Again, thank you for having me virtually. As identified, I'm up here this afternoon to present 3 reports, attending before your Council as the Integrity Commissioner for the Corporation of the Township of Oro-Medonte. As indicated, Your Worship, I will be dealing with 3 reports, so it is sort of a lengthy process. I will try to keep, for the sake of brevity, just keep to the high points on each report. And as directed by Your Worship, I will deal with each report independently. I will stop at that point and receive direction from Council or questions through the Chair as indicated. So to commence, Your Worship, I'd like to start first with what we refer to as file number 3190, but for the purposes of your reference and Council's reference, this is the inquiry with respect to the alleged breach of the Municipal Conflict of Interest Act. And those are sections 5 brackets 1A, brackets B, and 14.3A and B of the MCIA. I'll refer to the Municipal Conflict of Interest Act as MCIA, the acronym rather than the full name. Again, it's assumed for the purposes of this afternoon, Your Worship, that all councils had an opportunity to review the report. And as such, I don't intend to take council through the report in word by word or page by page, but rather to stress some highlights in the report itself, and of course my finding and of course my recommendation. But by way of background, when we're dealing with an MCIA complaint, I think it's worth noting that unlike the Code of Conduct, the Municipal Act doesn't direct the procedure by which an integrity commissioner, again, I'll refer to as IC, is to follow in addressing MCI applications. It's a process which has to ensure that it's impartial, it's neutral, it's fulsome, it's engaging with not only the complainant, but the respondent. And particularly so with the MCIA, I would suggest, because of the consequences involved. This does, as Council's aware, carry severe sanctions, potentially, and it could result in a court application, which is my determination as to whether an application will be commenced through the Superior Court of Justice. So when I look at an MCIA complaint, I'm looking at first, was there a breach? And then secondly, I need to turn my mind to whether or not an application to the court is warranted. So it's essentially, it's a two-prong process of which I engage in when looking at allegations that the MCIA has been breached. I'm going to turn, Your Worship, to page 4, and I think a starting point here would be the nature of the complaint. So council's grounded as to what I'm talking about, and again, for the sake of brevity, I'm just going to sort of touch on what the highlights are. And in this particular case, Your Worship, the complaint was that a member of council contravened the MCIA by being present in council chamber when a delegation regarding short-term rentals was received by municipal council. And the day in question, Your Worship, is August the 14th, 2024. And specifically, the complaint as alleged by the complainant is based on the fact that the member had previously that day declared a conflict of interest regarding the subject of short-term rentals, but remained present during the delegation component of the agenda to hear two presentations, and they were identified as items 8A and B on the agenda for the August 14, 2024 regular meeting of council. And it was the position of the complainant that the member, being an operator of a short-term rental, contravened the provisions of the MCIA by being present, again, during the delegation, and more so by voting on the motion to receive the delegations as was put forward by council. And in doing so, it suggested or was alleged that the member had breached the MCIA due to having a pecuniary interest. In interviewing the complainant, the above facts were confirmed to me. In turn, I spoke to the respondent, the member of council, who did confirm, and this was confirmed by myself through viewing the video of the August 14, 2024 meeting, both at the outset of the inquiry as well as most recently at the time of finalizing my report. The member was indeed present on August 14, 2024. At that time, the member did remain in the council chamber at the table. And during the delegations, and I'll refer to them collectively, there were about 16 minutes in total. During that time, it was observed that the member made no comment, no question was directed by the member to the delegates, and in fact remained for the most part motionless during the presentation by the two delegations. The items were then received by council through a motion to receive, of which the member did in fact participate in that vote. And finally, in speaking with the respondent, member of council, it was confirmed that he was aware of the obligations and duties set forth in the MCIA and was cognizant of the fact that a member of council is to avoid any situation in which could result in a pecuniary interest being attributed to the member, family members, parent, spouse, child, as provided for by MCIA. Without sort of stating what the purpose of the MCIA is, Your Worship, it's obviously to avoid members of council voting in situations that could serve to advance or up or down negative impact into pecuniary interest. In short, anything that would impact on the financial interest of a member of council. And that means that any decisions of council that each individual member of council has to take into consideration of whether a pecuniary interest exists, and in doing so must act in a way that's impartial, unbiased, without any financial interest to the member, always putting first the interest of the municipality, a body of official duty. In looking at this matter, Your Worship, I did have to consider whether or not the respondent contravened what is sections 5 brackets 1 brackets A, B of the MCIA, and in turn section 14.3 A and B of the MCIA. In doing so, and as indicated, I then have to make a determination whether an application is to be made to the Ontario Superior Court of Justice as it relates to this alleged breach. In considering both matters, the answer was no, and here are the reasons why. Based on the information provided by the respondent in response to the complaint, I'm satisfied that the respondent member understood his obligations under the MCIA. And in considering this matter, I had to have regard to whether or not the hypothetical question is what pecuniary interest, what financial interest would be gained by this member having sat through the delegation and then subsequently voting on the receipt of the delegation. It had no bearing that I could see on the financial interest of this member. And to do so, I would be into the area of speculating as to what it might be, and again, in the area of hypothetical questions, which is not the jurisdiction of an IC when considering allegations of breaches of the MCIA. Furthermore, the receipt of the delegations and the attendance during the delegations did not, in my opinion, constitute an advancement of any business of the municipality. And perhaps I could have been more fulsome in this regard, but it's been well established that the mere receipt of information by a municipal council does not materially advance the business or decision-making of the municipality. Delegations once received, can form decision-making or can be seen as materially advancing the business of the municipality. That's only in the situations in which there's debate, there's questions of the delegates, there's direction to staff, there's further direction to have the matter come back. None of that occurred on August the 14th, 2024. And as such, it was my finding that there has to be a pecuniary interest existing at that time. That is during the presence of the member of council during items 8A and B in order to form any suggestion or allegation that there was in fact a breach of the MCIA. I could not find so. And as such, my finding was that the member did not breach the MCIA by being in attendance. As indicated, no questions were directed. Council, in fact, there were no questions put by members of council, simply the receipt of the materials itself. Furthermore, the member himself, by voting on the receipt, was only voting to receive the information. Finally, as I indicated, there was no suggestion or evidence provided to me by the complainant as to what the pecuniary interest actually was. What was the subject matter that the member was allegedly had voted in or participated in that would somehow advance the financial interest of the member? So having found that there was no breach of the MCIA, I next had to turn my mind to whether this matter warranted an application to the court. And an application to the courts under MCIA, Your Worship, is a very serious step to be taken by a municipality, particularly in light of the circumstances that cost consequences could flow from an unsuccessful prosecution under MCIA. And any application to the courts under MCIA, as council is well aware, is done so not with my money, not with your money, but rather the municipal money. That is the taxpayers' dollars. So any consideration of an application is a most serious thought put into it. And in this case, where there would be limited, if no success, in my opinion, given my finding that there was no breach of the MCIA, it was my recommendation decision that there would be no application to the courts arising from this. Again, Your Worship, by way of closing remark, I'm always mindful of the fact that all members of council need to be fully aware of MCIA when participating in decisions in which pecuniary interest may be present, and that all members of council are indeed required to put the interest of the municipality first above that of any pecuniary interest which a member may possess. So that was the finding on that particular matter, Your Worship. As such, there were no recommendations put forward, as there was no finding of a breach of MCIA. And as indicated, I'm happy to answer any questions you or council may have with respect to this matter.
Thank you very much, Mr. Ewart. I will open the floor now for any questions from council members. Councillor Young.
Yeah, thank you, Mayor. I don't have a question. I just want to compliment the Commissioner on the report itself, but not more so, but as well as your thorough explanation going through the report. Thank you.
Councillor Hutchison.
Thank you. Through you, Mayor Greenlaw. Just so that I and the public are very clear on this, because the concern, you know, in a nutshell, was basically that the member sat through a delegation that lasted 16 minutes and then voted to accept the delegation's submission. Just if there had been a debate with regard to the topic or the subject of the delegation by members of council, would that have changed the outcome? I'm trying to understand in the interpretation that if the member involved had asked questions or had been involved with debate, that could have been perceived as looking to move the business of the township forward versus just listening and accepting.
Through your worship, and thank you for that question. And it's right on point as to what the distinction is. There's a recent case, recent being 2019, I guess that's recent in my books, of the Ombudsman's Office, and it's City, Hamilton. And I think it's probably instructive, your worship, if I read from that decision. This is from Mr. Paul Dubé himself, and Ombudsman at the time for the province of Ontario. And he sort of answered that question as to when does the business of a municipality, when is it materially advanced during delegations? And I'm just going to read a portion of it. It's not contained in the report. I'm happy to provide a copy to the clerk if council wishes to see it afterwards. But it goes like this, and this is paragraph 69. And what the ombudsman wrote was this: mere receipt or exchange of information is unlikely to materially advance business or decision making as long as there's no attempt to discuss or debate that information as it relates to a specific matter that is or will be before a council, committee, or local board. And the Ombudsman's Office further went on to say actions, and these are what we refer to as factual indicators, actions like voting, reaching agreement, providing direction or input to staff, discussing or debating a proposal, a course of action or strategy. These are all factual indicators that business or decision making has materially been advanced. On the other hand, merely receiving information does not materially advance business or decision making. And I was cognizant of that decision when I was looking at this matter as to just exactly what had entailed over that 16 minutes. To answer the question, then, your worship, directly to the member of council, had there been, for example, debate or discussion on the issue, rather than simply to receive it, or if the matter had been referred to another item even on the agenda, for example, or if it had been referred to a committee or city staff for a further report, or if it was ever even referred to new business for information, that would have taken it out of the realm of just simply merely receiving information, and that would have been closer along the lines or to the spectrum of advancing material business. But simply receiving information, which is often done with delegations, that's, again, that would have been the proper course. But had there been further involvement or engagement, both by the member and council in participation, that would have taken out of the realm of just simply merely receiving information. That's a long-winded explanation, your worship. I understand that, but hopefully that's instructive.
No, thank you very much. Any other questions? No supplemental? Any other questions at this time? Seeing that, I guess one thing I would just like to know if there is a path or something we can help remedy these things, because council meetings can be overwhelming at times, and there could be a lot of things on the agenda and a lot of moving parts. How do you advise a member of council to err on the side of caution on things that you know may get them into a pecuniary or conflict of interest? Because my understanding is we're not allowed to bring it to their attention. It would save a lot of potential public outcry on issues like this that we could prevent in the future. Is there any recommendations or suggestions you might want to make?
Thank you, Worship. There is. And obviously, I think that the obvious one is if there's any topic of which there might be contention or objection, is then to not be present. That's I think the obvious one. On the other hand, I've seen decisions that say that members of council should not be dissuaded from participating or being present during matters in which there truly isn't a pecuniary interest. But that determination is a tough one. And as His Worship pointed out, it's not up to the clerk or the CAO or senior staff to advise members of council, hey, you have a conflict of interest. So I think to avoid it altogether, you stay away. And not only when I mean stay away, I mean you don't even, you leave the council chambers. That's the best practice. Again, amongst ICs, that information or that position is split. Some say you don't have to. I'm of the other side. You must leave. If you have a conflict, you leave. But to avoid this altogether, if it's a topic or a subject which may be visited upon you, I think the best advice would be just be absolutely away from it. But as I say, on the other hand, I've seen decisions, Your Worship, that say it's not fair to have members not be present or at least participate when that interest is not there. But that's a fine line. That's deciding. You're taking that on yourself by way of determining whether one has a conflict of interest or not. And if you misgauge that or if you misjudge that and I don't see it or someone like me doesn't see it that way, then that's where the problems arise. So the safest bet is always not to be around it.
Okay, no, thank you very much. No. So is there any other questions? If not, I'll ask for the motion by the clerk. Madam Clerk?
Mr. Mayor, may I have a mover and a seconder, please?
Councillor Bard and Councillor Clark.
Moved by Bard, seconded by Clark. Be it resolved that the report dated February 5th, 2025, and presented by John Eward, O'Dwyer, Re OM IC report file 3190 be received.
I'll call the vote. All in favor? That is carried.
Thank you.
So, Mr. Ewart, whenever you're ready, we can proceed.
Thank you, sir.
Oh, my apologies. You know what? I didn't call. All opposed. Oh, I have no opposed. So, anyways, that did carry. Thank you very much. Please, Mr. Ewart, continue on.
Thank you, sir. The next matter I'm going to report on is file number 3019, and for the purposes of reference by council, this is an allegation that there was a breach of code of conduct, the municipal code of conduct, various sections cited, too many for me to name off the top. It's in the subject line, and it pertains to the events arising from a posting by member council to a community Facebook group, and that occurred on February 9, 2024. Again, I will sort of set out the background in a brief manner, Your Worship, with the understanding and hopes that all members of council have read this. The occasion or the complaint comes about as a result of the nature of the postings by the member of council to a Facebook page. And this is, I guess I'll preface this by saying this is becoming more and more a concern, the use of social media. It is just a fact that it's another way of communicating with the public, including members of council to their constituents. But in this particular case, this allegation is that the member of council, through the postings, had contravened various sections of the code of conduct. And in doing so, I tried to set out what I understood to be sort of the distillation, if you will, of the complaint itself. So I'm going to turn first, Your Worship, to what's page 4, and it's the background facts. And again, facts aren't very complex, but they're complex in terms of what the postings constituted and whether or not they were a breach of the code of conduct. So the complaint itself as received. Now, I'm going to also at this point indicate that when I receive a complaint, and I make a comment of this in my report, I have to receive the complaint as received. I can't sort of try to direct the complainant. That would be most unfair, not only to the process, but to the respondents. So I have to take the complaint as I find it. And this can be troublesome, particularly when many sections of the code are cited. In this case, there were 28 sections. So I've tried to distill it down. But as I indicate in the background facts, the postings occurred over the course of February 9, 2024, at which time the member responded to and engaged in conversation. I'll refer to as a conversation online through postings with a resident. And it all began over the issue of tree cutting. And as indicate the nature of the complaint, 28 sections of the code that I was directed to. Despite the 28 sections, there were 5 examples provided in the complaint itself. And rather trying to go through each of the sections, I did try to distill it down to what I believe, based on conversations with the complainant and multiple submissions, as to what the issues really were. And they're identified, if you will, on page 5. And I'm just going to read this aloud, and then I'll address each of them individually, Your Worship. So the first was, did the member, through his posting to a community Facebook account, make statements that he knew to be false or mislead members of the public, contrary to the provisions of the Municipal Code of Conduct? And the second allegation or issue, as I saw it, based on the complaint, did the member contravene sections of the Municipal Code of Conduct by failing to treat members of the public with dignity, understanding, and respect? And thirdly, did the posting by the member to a community Facebook account constitute a form of abuse, bullying, or intimidation contrary to the Municipal Code of Conduct? Now, in credit to the Township of Oro-Medonte, your Code of Conduct actually in Section 15 actually deals with social media, and I think that's to your credit. So we have some guidance, or I have some guidance when I'm looking at this. But this particular complaint, and I think it's important that I identify this right now, that the complaint occurred on February 9, 2024. I mean, I had submissions right up to December 4th and 14th of 2024 to finalize this. But they were directed to an individual who was not the complainant itself. And that is concerning. And I'll speak about that further. And it actually was the subject of discussion by other decisions involving integrity commissioners. But as I note here, the individual who was the subject of the post made by the member had not complained. I did not receive a complaint from that individual. And the actions of the member, nor has the individual never contacted my office, despite requests made of the complainant to somehow get in touch with this individual. So that was sort of the background of which this report was generated. But the significance of this is, as I note here, is that my office was being asked to review the conduct of a member of council with respect to Facebook postings being complained of by another member of the public who was not the subject of the postings. And that made it difficult, to say the least. But in any event, I proceeded with the inquiry because I believe there was enough, based on the multitude of sections cited and the fact that this was framed in such a way that it was warranted the inquiry. And so on that basis, I moved forward, understanding that I'm dealing with a complaint on behalf of a member of the public against another member of the public who I'm not hearing from and I'm unable to contact. So with that in mind, Your Worship, I want to turn to the actual issues in my findings. And that's starting on page 8. And in issue A, which is, did the member make postings to the Facebook that were false, misleading, or contrary to Municipal Code of Conduct? And as I indicate, the role of municipal council members includes communicating with members of the council, members of the public about local issues. And this includes responding to issues as well. And it was my finding that issues such as responding also includes initiating communication with the public through the use of social media and social platforms such as Facebook. And in fact, the courts have sort of weighed in on this, and in fact, clearly stated that an elected representative of the public, a municipal councillor, is actually entitled to adopt a role in that form. And as part of the political process, a council member has every right to form views, to hold views, to express views, and while in office, and to give effect to those views through mediums such as social media. And I've referenced a particular decision too involving what was Greetrex and Williams. That involved the former mayor of Orangeville, where it was the finding of the Integrity Commissioner that given the political and representational roles of a municipal councillor, whether on controversial or highly visible topics, these are ones in which a member council is in fact entitled to communicate, in which a council member is entitled to participate. The second concern I had, though, with this particular issue was, and it's a principle I've cited, the person who asserts must prove. So here, the allegation here was that that the member was engaged in the dissemination of false or inaccurate information, and in doing so, the member may be subject to the consequences under your code of conduct. But in the case at hand, the onus doesn't lie on the member council to prove that his comments were accurate or not truthful. Rather, the contrary. The member can only be found to have contravened the code of conduct if it's established his comments were inaccurate, untrue, or misleading. But that was not established through the evidence. And that's where I had problems with this complaint. Finally, the code of conduct does not apply to opinions held by members of council. Expressions of political opinion lies outside of my jurisdiction, and this was stated in a case called Miles versus Fording, which I've cited. It's not for the Integrity Commissioner to pronounce an opinion true or false, but rather the statement of opinion is subject to being tested through political debate. So accordingly, it was my finding that on the first issue, there was no contravention of the Municipal Code of Conduct, and in particular sections 2.2, sections 4.1, and section 5.0A, which is your social media component. The second issue, and I'll just again read this aloud just to make sure everybody's following along, is did the member contravene the Municipal Code of Conduct by failing to treat a member of the public with dignity, understanding, and respect by posts to the Moonstone Community Facebook social platform? As indicated in the report, Your Worship, there's no dispute that the Code of Conduct does require all members of council to treat people with dignity, understanding, and respect. It's a function of, however, of the context. And in this case, the context is that people voluntarily engage in social media through the postings to a Facebook page. And the postings which were being complained of was essentially a public conversation of which was visible to a wide potential audience. And in the context of social media, it was my finding that it's relevant in this inquiry that the parties involved were voluntary participants in the online conversation. In this regard, as I note, if you make a post, you can expect somebody to respond to the post. And if you criticize someone online, you can expect to be criticized in turn. And that's the nature of social media. And perhaps more importantly, however, this was also the finding in an earlier case of the Integrity Commissioner in Montfort and Brown involving a council member's use of social media. As noted, I don't disagree that everyone is to be treated with respect and dignity as required by section 15.0B of your code of conduct. But when engaged in social media, such concepts need to be shaped by the conversation and its context. I'm going to turn to the third issue, Your Worship, and this is again, I'm on page 10. Did the postings to the Facebook constitute a form of abuse, bullying, or intimidation contrary to the Municipal Code of Conduct? And that's section 9. And it was my finding that it did not fail to treat the member or member of the public as such. And upon reviewing the evidence provided by the complainant, Your Worship, it was also my finding that members' posts did not constitute any form of bullying or intimidation. And it's looking at this and arriving at this decision, I was very much guided by the case of Chan versus Therian. And for those who don't recall, Diane Therian was the mayor of City of Peterborough, which I also act as Integrity Commissioner. I did not do this inquiry. It was done by my co-Integrity Commissioner. But it's important, I think, to refer to those comments in that decision. I'm just going to read them. They're in the report. But it's essential to understand that nobody, in finding in that case, there was no misdoing by the former mayor of Peterborough in her postings, and they were somewhat, how can I say it, contentious in terms of what was said and the language used. But the important thing is that nobody's required to follow the mayor. People are not confronted with her opinions. They choose to access them. And Canadian courts have underscored the difference between messages that people can avoid and those that have a captive audience. And in doing so, there's reference as well, Your Worship, to it's the Comity, Commonwealth of Canada, and that's a decision of the Supreme Court of Canada, where it says that people who choose to access the mayor's post will see them. In my view, their voluntary engagement with her online content is inconsistent with the finding that they are being abused, bullied, or intimidated. One cannot be bullied or intimidated by a message that one need never view in the first place, and that one is free to ignore. So that's very, very instructive, in my opinion, in terms of not only the comments in the court, in that one can't be bullied or intimidated by postings one doesn't need to view in the first place. And as such, it was my finding that there was no contravention as it relates to that issue by the postings. And I just want to go on a little bit further, having found that there was no contravention of the Code of Conduct. Just some comments, Your Worship, if I could, with respect to this particular inquiry. And as I indicated earlier, I had concerns about the lack of contact from the individual who was in fact the subject of the postings being complained of by a third party. Again, valid, I undertook the inquiry, but it was a concern. But as a general matter, and I say this generally, that integrity commissioners should be very reluctant to inquire into allegations of bullying, abuse, intimidation, harassment, unless it's brought by the person alleged to have been the subject of such actions. And that was the finding in the case called Miller versus Bath Hayden. I've cited that as well, too. And I should indicate, Your Worship, if council or yourself want to see these decisions, I can certainly pass them on. I reference them because they're obviously instructive and they guide me in the jurisprudence of this area. But if council thinks it's instructive, I will certainly pass this on to the clerk. And then as well in Part 5.1 of the Municipal Act does make it clear that the role of the Integrity Commissioner is in dealing with Code of Conduct complaints. They're complaint driven or request driven. And that means that in the case of alleged contravention of the Municipal Code of Conduct, it would be expected that the person who was impacted by the member's comments or statements would have come forward to either initiate or participate or support the complaint, which I did not receive. However, I did proceed with this inquiry due to the large number of alleged violations put forward by the complainant, which I distilled into the 3 issues that I addressed, and of which I found there was no breach of the Code of Conduct. And then in summary, I'll just drop down to that, Your Worship, that having found that there was no contravention in the Code of Conduct, I do make again the following comments as general statements. To say my role as Integrity Commissioner is not to tell members of council how to communicate with its constituents. That's not my role. My role is limited only to applying the Municipal Code of Conduct. And in conducting this inquiry, I'm directed by the complaint and guided by the sections of the Municipal Code of Conduct. However, it's of little assistance to me in conducting these type of inquiries if I'm presented with a complaint that has reference to numerous sections of the Code of Conduct, but no particulars being provided. It's not my role to fit the evidence received from the complainant into the sections of the Code of Conduct. That would skewer the process. Moreover, the process is, I have to be directed through the Code of Conduct to the evidence, not the other way around, because I think that would serve to really prejudice all involved, and it would certainly serve to perhaps upset the integrity of the whole process. And finally, again, I am concerned that this inquiry was initiated as a result of concerns of a complaint by a member of council involving a member who had not filed the complaint. And for the reasons I referred to earlier, that is something that the IC should be very reluctant to engage in. I did so because of the nature of the complaints and the volume, but it's something that I really had concerns in dealing with third-party complaints. Having said all that and having put this forward in the report itself, Your Worship, it was my finding that the member in this particular case, that is the postings of February 9, 2024 to that community Facebook page, did not contravene the Municipal Code of Conduct. Subject to questions you and council may have, Your Worship, that's the balance and the substance of my report.
Thank you very much, Commissioner Ewart. I'll open the floor now for any questions or comments to Mr. Ewert. Councillor Young?
Yeah, thank you, Mayor. Just one question, Commissioner. Regarding that person you attempted to contact and never did contact, or at least they didn't get back to you, I'm familiar with the posting on February 9th as a member of the Moonstone community. If that person is known, or at least the entity, they're a bit of a non-person. It's a pseudonym that's being used by someone else, and that's confirmed somewhat by your and the fact you're unable to contact them or they're unable to get back to you. Now, if that name, the poster, is known, can that name be publicly known, or at least publicized?
Through your worship, I don't know if I can answer that, your worship. That's not my role as IC. I'm restricted solely to the nature of the complaint. Whether the individual existed or not, I can't provide comment on, nor can I serve to identify what I believe. That's not, again, as indicated, it's not my role. I have to rely on the complaint itself, but I was, as indicated, and was concerned that the complainant was not the individual who may have been the subject of postings by the member. That's just a fact, and that's how I had to rely upon or gauge my response to that. But to answer your question directly, I don't know. It's not my role. If it is, it's certainly not my role as IC, so I don't think I can properly respond to that.
Yeah, thank you, Commissioner.
Okay. Is there any other questions regarding this item? Deputy Mayor Lavoie?
Yes, thank you very much. I also echo the concerns with regard to a complaint made on behalf of another person. Is there anything that bars the respondent from identifying themselves in this process?
No. Again, I always try to preserve, and as it noted in all my reports, I try to preserve the confidentiality. It's not mine to waive. If a respondent wished to identify him or herself as the subject of the complaint, that is entirely up to he or she. I try to go up maybe to the far end of things in terms of not identifying any of the parties involved, but no, there's no restriction on that. The only restriction being that if a respondent identifies him or herself and refers to anything in my report which may not be complete or accurate, I'm then obligated to come forward and to respond to that. But no, there's nothing that would in and of itself prohibit the waiver, if you will, of confidentiality that I always preserve. In fact, it's not even referred to as confidentiality. In the municipal act, it's referred to as secrecy. So it gives you the type of ideas, the level of confidentiality to be preserved.
Thank you very much.
Okay. Is there any other questions on this matter? Seeing none, Madam Clerk, actually, do I have a mover for this item? Councillor Clark, and a seconder, Councillor Hutchison. And if we could have the motion, please. Thank you.
Moved by Clark, seconded by Hutchison. Be it resolved that the report dated February 5th, 2025, and presented by John Ewert, Heward O'Dwyer, Re OMIC, report file 3019, be received.
I'll call the vote. All in favor? Opposed? I don't know where. Councillor Schell, is your camera off?
We've lost Councillor Schell.
Okay. Just if we're gonna take just we don't need to leave our seats because it's like herding cats. So we will just, if someone can try and contact Councillor Schell, see if we can get him back online before we proceed.
Here we are.
Okay. Yes, yeah. Yeah. Councillor, we can't hear you in Councillor Schell, so I'm just wondering, when you logged back in, did you got to accept, because you're off site, you're going to have to accept the audio from your computer. Is that correct, Madam Clerk? So
That's correct.
you've likely come in as if you're sitting in chamber. My recommendation would be log out, log back in, and when it prompts you to use your laptop audio, you have to accept that so that we can hear you if you have a question or anything, so. No, but we can't hear you now.
We can't hear you, Councillor
What you're
Shell.
gonna have to do is log out, just log out, and then come back in, but don't just X out the audio prompts, accept them, please. Okay. Still can't, we still.
No, Councillor Shell, we still can't hear you. So down to the left, bottom left of your screen, you will see audio. Click on that.
You're muted right now.
Hey, we'll have IT call you.
Well, he's unmuted now, but I can't hear him still. You may have to turn your volume up on your speaker. Try your volume on your bottom right-hand corner of your screen, and you may have to turn that up.
No, we still can't hear you. Oh, he's gone. Councillor Shell, we're going to have IT remote in to your computer. We can't hear you, so we're having IT remote into your computer.
Oh, family day, yeah, nice.
Councillor Shell, you need to do a reboot. Sorry. Councillor Shell, you need to do a reboot, please. We can't hear you. You need to do a reboot. You can hear me, I know, that's because of the way our system is, but we can't hear you. So if you can do a reboot, that will be great. We'll have IT call you.
So do you want to take a 5-minute, or do you want to just wait?
Yes, Mr. Mayor, we'll take a 5-minute
Commissioner
break.
Ewart, I apologize for this. We're just going to take a 5-minute break, and no counselors leave the building, please.
Councillor Shell, stand by. IT will be in contact with you.
Okay, so 3 minutes after for Commissioner Ewart, and then we'll reconvene. Is that okay?
Very good. Thank you.
Thank you, sir. Here we go. Bingo.
Folks connected to the audio, you'll have to mute your mic on your computer. Okay, there we go.
Okay. Perfect. Okay, Madam Clerk. Just
Mr. Mayor, we are live.
yeah.
We're going to have IT remote in again and turn the volume off on the computer because the phone and the computer are competing.
Okay.
No, no.
Okay.
There, my phone's telling me one thing. Computer's not saying anything to me now.
Okay, perfect. We can hear you. Thank you.
That's good. Okay. So, Madam Clerk, let us know when we're counted back in, and we'll resume and allow Commissioner Ewert to give his final report.
Mr. Mayor, we are live.
Okay. Thank you very much. Commissioner Ewert, if you want to give the third and final report when you're ready, please proceed.
Thank you, Your Worship. The third report and final report of today, Your Worship, pertains to file number 3050. And for reference for council, this is the allegation of a contravention of both the Municipal Council Code of Conduct, as well as violation of the council and staff relation policies, which is POL-HR-7.09. Your Worship, this matter first came before council in early December. Direction of council at the time was to have further inquiry undertaken by myself with respect to the report not being received at that time. In accordance with those directions, a further review of this matter was undertaken by our office, and specifically the further inquiry was involved specifically the timing of events of which occurred on the date in question being August 30th, 2023. And in doing so, I've added as part of this report, because I think it's important, the notes of the bylaw enforcement officer who was in attendance at that time at private property on August 30th, 2023, in carrying out municipal bylaw enforcement. And again, that's referenced in the report itself. It's of note that there's no formal record as to what transpired. It took place on private property, but we do have the notes of the municipal bylaw enforcement officer who confirmed to me that the notes were taken in the normal course of business and were done contemporaneous at the time. So they do form, if you will, somewhat accurate timestamp, at least as far as I'm concerned, in terms of trying to track what happened. And the events that we're talking about transpired August 30th, 2023, commencing at 2:10 p.m. In my report, I think my first report referenced morning. I've corrected that subsequently, but it's 2:10 in the afternoon for approximately 45 minutes, although the total time in which the engagement or interaction between the member of council and the bylaw enforcement officer was somewhat less than that, approximately 10 minutes, based on our review, again, of the records and confirmation by the bylaw enforcement officer. I'm just going to go to the background facts, Your Worship, for those. I know this has been before council before, but I think it bears repeating. This is on page 4, where we indicate that the events leading up to the complaint as against a member of council are not complicated, but what occurred on the afternoon of August 30th are and do remain in dispute. And the crux of the matter pertains to a bylaw enforcement officer attending at private property, which was known to be operating a short-term rental accommodation. And about the same time, the member of council also attended the subject property. And how the member of council came to be at the property at the same time as the bylaw enforcement officer is in dispute. However, what occurred during that time, which the member of council and the bylaw enforcement officer were present, I'm going to stop saying bylaw enforcement and say officer, were in attendance, really forms the basis of the complaint. And specifically, the complaint involving the member of council is, did the attendance at private property by the member while bylaw enforcement was conducting an investigation, served to hinder or otherwise interfere with the duties of the bylaw enforcement officer. And in turn, were the actions of the member of council contrary to the provisions of the Municipal Code of Conduct, sections 5.1, 5.3, and 5.5 brackets B. And thirdly, did the actions of the member of council set out above, were they contrary to the provisions of the council and staff relationship policy, POL-HR 7.09? I've identified in the report both the position of the complainant as well as that of the respondent. And it's the position of the complainant that the member of council violated the Municipal Code of Conduct when the member attended at the property, which was the subject of an investigation and potential charge by municipal bylaw enforcement. And based on the notes of the investigating officer and confirming with the officer as well, once having been advised of the reason for bylaw enforcement attending, the member of council then remained on site for approximately 10 minutes. During this period of time, the officer was questioned as to why she was there, and ultimately the member did leave, but it's important to note that during that period of at least 10 minutes, if not longer, but 10 minutes as we understand it, there was this interchange or exchange between the member and the bylaw enforcement officer itself. Of concern in the matter is the fact that the officer indicated to the member that she would only speak with the property owner without the member being present. And to the member's credit, the member did leave, returned to his vehicle, and parked on the other side of the road. But the concern was that what exchanged and what occurred during that brief period of time, and how the member and bylaw came to be there at the same time. In response, member of council advised that his attendance at the property was the result of a prearranged meeting with the property owner. At the time of arriving at the property, the member recalls the officer arriving at approximately the same time. Upon being advised by the officer that she would not speak with the property owner in the presence of the member of council, the member left the property, returned to his vehicle, parked down the street in order to allow for the member to keep his scheduled appointment with the property owner once investigation was completed. There's a recollection of the member of council that total time, which concurs with the notes, was approximately 10 minutes in duration. I note that the officer had recorded in her notes the time of her arrival at the subject property, 2:10 or 14:10, and the time of departure being 45 minutes. There was no record made as to the total time that the member was actually on site. The events of August 30th were subsequently reported to the CAO of the municipality and by municipal staff, who then addressed the incident with the member of council on September 25, 2023. Now, I think it's important to state, Your Worship, that in looking at the alleged contravention of the Code of Conduct, the use that was being made of the property is not the issue. What is the subject matter and the purpose of the inquiry was what brought the bylaw enforcement officer and the officer together. The subject matter of how the officer was there, came to be there, is not relevant to the complaint that I had been asked to investigate. The sole issue is whether the member of council contravened the Code of Conduct when he attended at the property and allegedly interfered with the investigation of the bylaw enforcement officer. I've identified in the report itself, Your Worship, relevant sections of the council and staff relationship policy. The council for the Township of Oro-Medonte saw fit to adopt a council and staff relationship policy, which attempts to ensure that council and staff share a common basis of their respective roles and responsibilities. And the standards of conduct, as set out in that policy, serve to govern the relationship between members of council and staff, both of which are expected to adhere to and comply with. And furthermore, this staff code, the staff relationship, council staff relationship, is further embedded right in your municipal code of conduct in section 5.3, confirming the importance of this policy to the municipality itself. In looking at the sole issue that I saw was the subject of inquiry, simply put, did the member of council breach section 5.0 of the Municipal Code of Conduct by interacting with the bylaw enforcement officer during a bylaw enforcement investigation? And based on my analysis of what is set out in page 8, and again confirmed by the notes that I've now added for council's edification, it did appear that the member of council did in fact intervene in that investigation. And what was of note to myself in looking at this and of concern was the fact that during the time in which the member and the officer were together, the officer indicates that the need for the member to excuse himself and that his presence and attempts to intervene were, quote, inappropriate. These are words taken from the notes and confirmed to me again. And as such, it was my finding that this intervention, this mere presence, the failure to leave immediately upon being advised that an officer was on scene investigating a matter, did serve to put the member of council offside with not only the council staff policy, but in turn, section 5.0 of the municipal code of conduct. And as such, it was my finding that it remains my finding that there was a breach of the code of conduct, and that this involvement in this breach was worthy of reprimand. And I've set out the reprimand and sanction in the recommendation itself. A further concern in speaking again with the bylaw enforcement officer was that the member was maybe siding with the property owner. And that was a concern that to the officer, which resulted again primarily in the officer requesting the member to not be present during the discussion. And enforcement actions, as I note, always start with a site visit. They always then an assessment of next steps. But the actions of the member of council in this case, by being present, albeit for a very brief period of time, and asserting himself and inserting himself into the enforcement process, the problem was that the member council was not the person authorized to take those steps and did not have the authority to do so. And that's, if you will, the crossing of the line, your worship. And in doing so, there was my finding that there was a contravention. And I indicate in the report itself, and I'll turn to the recommendations in a moment, but there are consequences and potential consequences to bylaw enforcement when something of this nature occurs. Staff are tasked with the administrative task of as established by council. It's staff's profession is to specifically enforce bylaw as directed by council. But when a member of council attends an investigation, even if well-intentioned, staff can still feel undermined, that councillors do not respect their professional judgment, and that councillors themselves feel that maybe they themselves, that is the officers, are unqualified. And that's a concern. And when the matter is that of bylaw enforcement, as I note, or enforcement matter, having a member of council impose themselves in the process makes it very difficult to prosecute and could result in an order of the court that evidence be suppressed because the municipality gathered evidence without legal authority. These are all possible scenarios and not just merely speculative. This could in fact occur. And under the legislation, staff has the right to inspect properties in circumstances, and in doing so, that evidence is admissible in court. Council members have no authority to engage in any operational matter, and any evidence gathered during investigation with a member of council present could be deemed to be inadmissible, and that could be unfortunate for the enforcement or the prosecution process itself. This obviously has serious repercussions for the township and underscores why councillors and officers, such as bylaw enforcement officers, must respect their respective roles. So in doing so, Your Worship, I tender this report with the following recommendation: that this report be received, that the member of council be subject to a reprimand for having been present during the investigation of a bylaw enforcement matter, contrary to the provisions of section 5.0 of the municipal code of conduct for the township of Oro-Medonte, and that council direct the treasurer to suspend 15 days of compensation paid to the member as a member of council commencing with the next pay period following the passage of any resolution. And finally, that the member be provided with a copy of this report, and that the member review policy HR-709 for the corporation of the township of Oro-Medonte. In doing so, those are my recommendations to council. And again, subject to any questions that council may have, that forms the balance of my report.
Thank you very much, Commissioner. Council, at this time I'll open the floor for any questions to the Commissioner. Councillor Young.
Thank you, Mayor John. I just got Commissioner, I just got a few comments, I guess, and I mean, I have real difficulty with the allegations which were sustained in terms of the member of council interfering or injecting himself or into the official duties of that officer there. And it's clear, and listening to your recital of the evidence there, that I view it as a serious matter, and it borders on obstruction as far as I'm concerned. And but I also have difficulty with the fact that there is a different set of facts from the officer and the member of council, you know, and I see that as undermining the competency, the credibility, and the integrity of that officer. The officer, she had no reason to be anything but forthright and honest with that, with what occurred there, you know, and it also, if it's established and proven via evidence, it also undermines the credibility of the member of council and his integrity as well. Again, if it's established that the evidence is supportive of the officer. But you know, I just made some notes and I read it, and you've gone through in depth the evidence in this matter, and I'm not going to comment a lot further on it, but you know, it's just the comments, and I'm just going to read this to you. You know, in terms of where's the line for all of us as members of this council in terms of what is deemed to be acceptable conduct and what may be viewed as misconduct. And I think that this case clearly demonstrates that the member of council crossed that line, and that the recommendations of you, sir, should be given serious considerations in light of the evidence in this matter. And I respectfully don't agree with your recommendations as indicated in your report. Thank you.
Thank you very much, Councillor Young. Deputy Mayor Lavoie.
Thank you very much, Mr. Mayor, and thank you for your comments, Councillor Young. I find myself deeply troubled by this entire matter. I think there's no evidence that supports anything other than what was offered up by the enforcement officer. The timing of the event, as related by the member of council, does not make sense. The officer was allegedly there for 45 minutes. In the words of the councillor, they arrived at the same time or contemporaneously. But the councillor was only there for 10 minutes. So this is not a set of circumstances that carries water. I think there's also evidence suggested in there that the resident indicated that the councillor indicated to the resident that what she was doing on her property was, in the words of the councillor, permitted use. This gives rise to concerns that the undertakings of council as a whole are not being carried into the public by all members of council. We are to support one another, whether or not we agree with our determinations and our rulings. But we have an honor to one another that if we undertake those determinations and rulings and pass those laws, that we will support them, that we will support each other, and we will support our staff. So I'm deeply disturbed, as I said, by this entire affair, and I would concur with Councillor Young, and I would move that we not pass the recommendation as stated, but that we deny it and that we replace item 3 with a much sterner penalty. I would contemplate up to 90 days, and I would put that forth to the floor once we read the motion. Thank you.
Any other comments at this time? Okay, well, I just want to make a couple of comments, and I think the commissioner was very clear in his report. Our role as council is one of governance, not administration or operational. And we need to be clear of that. We've been through training a number of times, and there is a line where we cannot cross. It's disheartening to see that this happened with a bylaw officer who was in uniform and driving a township identified vehicle, and a council member doesn't know or recognize the role of the person at the door. My concern is more because, as you reference, Commissioner, that the CAO had brought the member in to explain and address the issues on September 25th, 2023, and I was asked to attend that meeting as well by the CAO. And my concern is the inconsistencies in what was articulated to you by the complaintee and what was stated in that meeting. And that meeting was a mirror image of what the officer's report to you was. So all of a sudden it became now there was a pre-scheduled meeting, which I have a concern about, because that counselor should have been in a special council meeting that recessed the day before and continued at 1 o'clock that afternoon. And that was in everyone's calendar over a week in advance. And why you're scheduling a meeting with a constituent in the middle of a special council meeting does not make any sense. The reason we were given is that you went down there to interpret, to help interpret, because of the residents' language. English was not overly strong. And I question, I don't know, does the counselor that was attending that event, are they fluent in the tongue or the language that resident speaks? So there's a lot of inconsistencies and questions. I also am concerned because council's given clear direction, as the previous council, as a position on the matter that was being addressed. And this is where I think when decisions and direction has been given by council, opinions are one thing, but to inform somebody of something that contradicts the direction on a use that's not listed as a permitted use in that area is concerning. So I'll leave it at that and see, does anybody else have any comments at this time? Seeing none, then Madam Clerk, I will ask for the mover and seconder of this motion. Does anyone wish to move or second?
I'll move.
So Deputy Mayor Lavoie will move, and Councillor Young will second. And could we have the motion, please?
Moved by Lavoie, seconded by Young. Be it resolved that the correspondence and subsequent revised report dated February 12, 2025, and presented by John Heward O'Dwyer, Re OMIC report file 3050, be received, including the sanctions recommended by the Integrity Commissioner in said report. That the member of council be subject to a reprimand for having been present during the investigation of a bylaw enforcement matter contrary to the provisions of Section 5 of the Municipal Code of Conduct. that council direct the treasurer to suspend 15 days of the compensation pay to the member as a member of council, commencing with the next pay period following the passing of this resolution, and that the member be provided with a copy of this report, and that the member review policy POL HR-7 .09 for the Corporation of the Township of Oro-Medonte.
Thank you very much. I just have a quick question. The mover, is this just to get it to the floor? Does the mover have to support the motion?
Mr. Mayor, the mover or seconder do not have to support the motion. It is just to get it on the floor for discussion.
Okay. Thank you. So I'll open it to the floor if you want to discuss the motion, or do you want me just to call the vote? Deputy Mayor Lavoie?
My understanding is that we cannot amend the original motion as presented by the Integrity Commissioner. Is that correct?
Correct. The penalty cannot be amended. I believe. Mr. Ewart, would you like to give clarity to this? It appears to me that there is some, they want to have discussion as to whether or not they don't want to accept your 15-day reprimand. They want to have further discussion before actually putting the reprimand in play.
Yeah. So thank you, Worship. So if the issue is a different sanction or different penalty, both reprimand and sanction, I just remind council that under section 223.4 brackets 1A brackets 5, that a municipality may impose penalties on a member of council following a commissioner's report to the municipality that, in my opinion, his opinion, a member has contravened the code of conduct. So there is discretion if council wish to remove or keep the reprimand or suspension of the remuneration for up to 90 days. So council is at liberty, because the criteria has been met. There has been a finding by my office, there's been a contravention. So all I can make is recommendations. If council wishes to impose either of the following penalties, reprimand or suspension remuneration to the member up to 90 days, that's council's discretion, because the first criteria being satisfied, a finding that there's a contravention. I hope that makes things clear for council.
I'll put it in my simple terms. Whether the reprimand number of days of suspension is increased or decreased, are we best to decline this motion in its entirety and bring forward a second motion, in which would be to receive the report and implement the reprimand? Or would you suggest changing the reprimand on what's on the floor now after a discussion?
I think the best course of action, Your Worship, is to not receive my report as tabled, but to receive my report subject to any amendments if council's contemplating that.
So, woman. Okay. Thank you. I think we have that straight, Madam Clerk. Is that help you at all? Okay, so basically we're going to open the floor for a discussion now. The motion is on the floor, and then from the discussion, there may be a decision to either increase or decrease the number of days to the reprimand. Correct. Is that correct, Mr. Ewart? Do I have it somewhat right?
That is correct, Your Worship. So again, your discretion, or council's discretion, lies to alter either the reprimand or the suspension of pay, either up or down, or up, I should say.
Thank you. Okay, so members, I will open the floor at this time for any discussion or opinions you would like to weigh in on this. If he's all jump at once, no. Okay. Well, I will start by saying the concern is, I think that we need to address here is the inconsistency in the action. And like, you know, hopefully we don't want this to become an ongoing thing, but I'm concerned about the inconsistency of what the complaintee statement is to the Integrity Commissioner compared to what I heard in the meeting with CAO Dunn and what the officer has put in. So I think there's a number of inconsistencies that should not exist there, and they, two of the three versions I've heard align with what the officer has stated.
Mr. Mayor, we have lost a councillor.
Councillor Schell, can you hear us?
Yes, I can hear. I just been sitting too long with my injury, so I'd have to get up and move around.
Okay.
So I turned my camera off, but I can still hear you.
Okay, well, I would still have your camera on, and hopefully when you can come back in front of it, that would be great. But anyways, but
Well, I'm standing up, Mr. Mayor. It's been uncomfortable for me to be standing up in front of my camera in public.
We'll take a 5-minute recess for you to stretch, Counselor, and then we'll resume. Okay. So everyone shut their cameras off. And,
IT, we're taking a 5-minute recess.
Mr. I apologize.
Mr. Mayor, if council is ready, I will have IT count us in.
Thank you. Yes, council's ready.
Mr. Mayor, we're live.
Thank you very much, Madam Clerk. Okay, so where we are now is the motion's on the floor. We will discuss the motion and any recommendations. There seems to be an appetite to change the sanction, and then we will vote the original motion. And if you just want to keep it at 15 days, we'll vote on that first. If it doesn't pass, then we'll bring another motion forward to receive the report with whatever you feel is the fair compensation, or sanction, whether it is an increase or decrease in days. Okay? So, who would like to speak? Councillor Hutchison.
Thank you, Mayor Greenlaw, through you. I can echo the councillors that have already spoken on this matter. As to my dismay, actually, as to what has transpired here between a councillor and a bylaw officer representing our municipality. And I find it interesting that in Mr. Ewert's first report, he emphasized how we all as councillors must put the municipality first. And, you know, when we hear that a councillor has inserted himself into a situation and it was actually appeared to side with the resident versus what the bylaw officer was attempting to accomplish is extremely concerning to me. That is not what we do as councillors. That is not putting the municipality first. If I have a personal opinion that I don't agree with the decision of the rest of council, it's my job to ensure that I respect the decision of council in all of my communications and actions towards the public. And in this case, that clearly did not transpire, and it's very disappointing. Thank you.
Any other members of council? Deputy Mayor Lavoie.
Yeah, at the fear of repeating myself, I will indicate, however, that the Integrity Commissioner has pointed out in his report that councillors are not to insert themselves into the undertakings of staff, including investigations. And I just want to stress that amongst the staff, not without any indifference to the rest of staff, but bylaw officers are at the apex of investigations, because the consequences of their investigations are consequences that arise in court, and it's court evidence, and the undertakings of the township and the money that the township spends in order to arrive at a enforcement and a prosecution, and the decision to undertake it in the first place at the discretion of the bylaw officer is also something we should preserve and protect by way of our policy and principles. So again, I offer that as a thought in terms of what we contemplate as we move forward, and I would certainly support voting down the current recommendation for the substitution of a different suspension. Thank you.
Councillor Young.
Yeah, thank you, Mayor. I don't like being in this position. I don't think anybody on this council likes to be in this position when you've got to deal with these matters with a fellow member of council. As indicated, I am really disappointed in what has occurred. The member of council knew, or ought to have known, in seeing a bylaw officer in uniform, that there's investigation ongoing. And the genesis, as I see it, for that officer attending there and attempting to insert himself, or he did insert himself into the what was going on in terms of the conversation and the investigation, was his opposition, I guess, to short-term rentals, and that's been clearly established by but not only what what the commissioner has defined and clearly explained in his report, which he did. And Mr. or at least the counselor could be subpoenaed to court or summons the court as a witness in this matter, as he was present during the conversation between what occurred subsequently between the officer and likely the homeowner and himself as to what was stated by those parties during the conversation. So he's put himself in a bad position, but I am strongly opposed, and I mentioned here earlier that there's a different set of facts provided by the officer and the member of council. And again, I'll just say that speaks to or undermines the credibility of the officer. Who do you believe? I mean, the officer had no reason to say or repeat or anything but the truth. She has nothing to gain by doing so, and I think you have to give her evidence a lot of weight as to what happened there. So I'm going to vote this down. I think the penalties are more severe in light of the circumstances. And again, I say, you know, short of assaulting, I guess, a fellow member of council, this is pretty serious in the scheme of things. So.
Thank you. Any other comments? Councillor Clark?
Thank you, Mr. Mayor. Through you to the floor. Obviously, this is a really challenging situation to be put in for ourselves and as a member of council. And, you know, I'm thinking of it in a number of ways. You know, ought the member have known better? You know, I think, you know, hearing around the table, the answer is yes. Compounded the fact that, you know, as the deputy mayor pointed out, it was by law specifically. I would have an issue if any member of council themselves interfered with any ongoing operation, whether it's from a water operator or a snowplow operator. It's not our responsibility to interfere with their day-to-day obligations and duties, as in many cases they're the expert, and our role is purely governance. And and then I look at the incentives and the potential consequences, and how does that affect the behavior of the member that's under discussion, and are we going to see the change that we need? I'm not sure. You know, I think we are all very cognizant of the challenges of being an elected official and what is appropriate and what is inappropriate. It's a really, really challenging thing, and I guess I would leave with, we want to make sure that we're providing a clear and consistent framework for what we believe is appropriate conduct for a member of council. I don't think that this was appropriate conduct by a member of council, and the additional consideration is that all members of council were supposed to be at a specific place and time when this event occurred. That additional fact challenges my belief in the current slated suspension of pay.
Okay. Thank you, Councillor Clark. Any other comments? Councillor Bard?
Thank you, Mr. Mayor, through you. Yes, this is very difficult, and I echo many of the sentiments that have been shared here, but I'm struggling with the parallel here in which we've asked somebody to prepare a report. They prepared a report about somebody interjecting into somebody else doing their job. So that's the part that I struggle with. And if these are the recommendations, whether I personally agree with them or not, or disagree with them, this is what we asked to do. And it just seems that the parallels are just too much for me. So I like it as is.
Okay, thank you. If there's no other comments at this time, then I guess Madam Clerk will call the initial motion, please.
Would you like me to read the vote?
Yeah, just reread it, and then that way it's all concise. And then it was moved by, I believe, Councillor Lavoie and Councillor Young.
Moved by Lavoie, seconded by Young. Be it resolved that the correspondence and subsequent revised report dated February 12, 2025, and presented by John Ewart, Ewart O'Dwyer, Re. OMIC Report File 3050 be received, including the sanctions recommended by the Integrity Commissioner in said report. That the member of council be subject to a reprimand for having been present during the investigation of a bylaw enforcement matter contrary to the provisions of Section 5 of the Municipal Code of Conduct. That council direct the treasurer to suspend 15 days of the compensation paid to the member as a member of council commencing with the next pay period following the passing of this resolution, and that the member be provided with a copy of this report, and that the member review policy POL HR 7.09 for the corporation of the Township of Oro-Medonte.
Okay. Thank you very much. Everyone's heard the motion. I'll call the vote. All in favor? Opposed? It is denied. So can we have a second motion prepared, and I'll put on the table. So do you want to read the motion, and then we'll ask for a recommendation of what the days is being recommended, and we'll vote on that, please.
Well, Mr. Mayor, the motion, this motion was defeated. So if you are looking for another motion, it would be similar.
Okay.
Pending the discussion of council with respect to the days, less or minus
Okay, then
the 15.
Thank you very much. So would anyone like to put forward the number of days of the sanction being proposed? Deputy Mayor Lavoie.
Yeah, and I'd like to say a few words first. I mean, it has been brought out, and with very due respect to Councillor Bard's comment, we were in a closed meeting. All of us were there except for one member. We are to be seeing to the affairs of the township. That's what we ran for. That's what we were elected for, and that's what we should be doing. So I offer that in addition to the other comments that I made previously, and I'm not going to repeat them. So I see this as extremely serious, and again, I'm very disturbed and troubled by this set of events. It is a difficult situation for each of us to be in, and I'm sorry we're here today. I spent a lot of time over the weekend ruminating about it and concerned about it and thinking about it, and nonetheless, here we are, and I can't think of something that anyone could do that would be any more egregious than what we're faced with today. So I'm going to put 90 days on the floor. Thank you.
And do I have a seconder for? So you'll move the motion, Deputy Mayor Lavoie, then, and then do I have a seconder for that motion? Yeah, Councillor Young.
Yeah, I just want to ask a question here. Procedurally, is there not a discussion as to the number of days? Is that? I thought that was.
We had the discussion about the matter, and then I said, okay, so we asked for a number of days, and the deputy mayor put forward 90 days, and now I'm asking, is there someone who will second this 90-day sanction? Okay, and if there's a seconder, then we'll call a vote on that, and it'll either be accepted or declined. And if not, then we'll take it from there. So do I have a seconder? Councillor Clark? Okay. So we have a mover and a seconder, Madam Clerk. It's basically the same motion. Do you want to read it, or do you want to?
Yes.
Please go ahead.
Moved by Lavoie, seconded by Clark. Be it resolved that the correspondence and subsequent revised report dated February 12th, 2025, as presented by John Eward, O'Dwyer, Re OMIC, report file 3050, be received. That the member of council be subject to a reprimand for having been present during the investigation of a bylaw enforcement matter contrary to the provisions of Section 5 of the Municipal Code of Conduct. That council direct the treasurer to suspend 90 days of the compensation paid to the member as a member of council, commencing with the next pay period following the passing of this resolution. That the member be provided with a copy of this report, and that the member review policy POL-HR-7.09 for the corporation of the Township of Oro-Medonte.
Thank you. You have a question by Councillor Clark.
If I may, Mr. Mayor, not necessarily a question on the motion, but a comment to the floor, if I may. I think what my support for a motion like this is to establish that every member of council should be held to these standards, and we're signifying that this was a serious breach of what we would consider conduct that's appropriate for a member of council, and we're setting now almost a precedent in the sense that we take this very seriously. So in the event, the unfortunate event in that another member of council sitting around the table has a momentary lapse of judgment, that we would reflect back on this in some ways and say the standard has been set, whether it's hopefully not myself making an error of judgment, but anyone around the table.
No, and I do agree with your comments. I think the situation at hand here is we were all to be in a special council meeting. I was advised that in the morning that member of council had to deal with something else, but I did explain that once you were done, to contact us, meet up with us, or we'd pick you up to continue on with a special council meeting. And no phone call came. We drove by the residence just because it was on the route in the vehicle sitting in the driveway. So there is a neglect of attending a meeting that was scheduled weeks in advance, which to me contradicts scheduling a meeting with a constituent during the exact same time period. That is my concern. So, you know, I think there's a lot of other things that may not be in the report that are connected to the meetings that took place after the report. That wasn't necessarily, because it wasn't the scope of the Integrity Commissioner's investigation. So anyways, any other comments at this time? And then Councillor Hutchison.
Thank you, Mayor Greenlaw, through you. Yeah, I like Deputy Mayor Lavoie. I've spent a lot of time ruminating over this. This is really difficult, and I personally am really disappointed. That's the word I'm using today. That we have as a council have been put in this position yet again.
Mr. Mayor, I apologize for the interruption, but we have lost Councillor Shell again.
Okay.
Councillor Shell, that way.
Yeah.
Scott.
There he
Okay.
is.
Oh,
There he is.
Yeah, I had to plug my phone's running out of battery, so I had to plug it in.
Okay.
So here we are again. My concern with 90 days is I'm not sure I'm not convinced that is actually going to have an impact on the behavior of the person involved. So, you know, and the recommendation from the IC is 15 days. I was more comfortable with 60 days. But I will follow the will of council, because I agree with all of the comments being made, and my additional comment of just being so disappointed that we have been put in this position yet again. And this is emotional. It impacts us personally and professionally, and that is that is just, you know, we should not be placing each other in this position as well. But I did want to say that I felt 60 days would be reasonable. But I will follow the will of council if the majority of council wants to go with 90.
Okay. Councillor Young?
Yeah, thank you, Mayor. Yeah, I agree with that it is a difficult thing for us to decide on another member of council. Considering everything, but I agree with Councillor Clark. My concern is the precedent it will set if we don't make the number of days, I guess, sort of fit the offense, if you want to call it that, the misconduct type of thing. And I agree that we have to set a standard. And as I said earlier, where's the line? You know, and I firmly believe that this line's been crossed with the conduct of the member of council. Having said that, and having debated with him myself on the weekend as well as here listening to everything, I concur in that 90 days should be set as the penalty, or whatever you want to call it.
Okay, thank you. I'm going to, Councillor Bard, and then we're going to call a vote, and then if it doesn't pass, then we will move to another number. So please, Councillor Barden.
Yeah, thank you, Mr. Mayor. Through you to the floor. And I'm not disputing any of the evidence that has come forward. I just would be more comfortable if it was in the report as presented and not discussion points. But to the point about this is very egregious and it needs a stiff penalty for sure. But I'm not comfortable because it wasn't in the report.
Okay. Fair enough. Okay, so you've heard the motion, and the number of days of the sanction is 90. It's set at 90, so I'll call the vote. All in favor? Opposed? That is carried. Okay. So Commissioner Ewart, I apologize for all the technical difficulties and our delays, but I do appreciate the thoroughness of your reports, and you know, I hope you don't get snow covered in the next 48 hours. It's, I hope, you know, I'm hoping the weatherman's wrong for a change. So,
well, thank you, Worship. Again, thank you, Council, for allowing me to attend virtually.
have a great day. Thank you.
Thank you, sir.
Okay, so let's, we'll slip back to where we left off. So we're now at item 11, reports of municipal officers for action, and there are none. So we will now move to item 12, reports of municipal officers for information only. May we have a draft motion, Madam Clerk?
Moved by Bard, seconded by Young, be it resolved that the reports as listed under item number 12, reports of municipal officers for information only, be received.
Okay. Thank you very much. So I just like to, the reports are very lengthy, but they're standardized and they're thorough. So there's a lot of information in all the reports, from testing results, bigger maintenance projects to provincial requirements. And I'm happy to know that these reports will also be posted on the township website so the public can view them themselves. Although these reports cover a lot of material matters, I appreciate how the reports are structured and presented in such a timely fashion. These reports confirm the public and council that the township meets the provincial requirements for these services, but also educates all of us on the delivery of these essential services and clearly demonstrates the township's commitment to service and understanding of the provincial requirements. I want to take a chance to really thank Ms. Jacoby and her team, who have consistently delivered the goods and met the standards. So I guess unless you want to speak, and I know you like to talk a lot, I'm just being sarcastic, my apologies, but just to confirm that everything in the system meets the provincial standards, and we're good to move forward into 2025.
Yes, sir, you're correct. They meet the compliance standards for their province.
Okay.
And I'd like to thank my team for their dedication in pushing this through probably faster than we ever have in the February meeting. So thank you to the team.
No, you know, as I said, you have an amazing team, and your leadership's greatly appreciated. So I guess, Madam Clerk, have you read the motion on this one? I apologize.
Councillor Schell, I wonder if I could have you just mute your phone, and then you can unmute when you want to speak, when you need to speak.
Or you know what, Councillor, just put your hand up, and then at least I can see it, because if I don't, you know.
Oh, I can't hear you if I turn this off.
Oh. No, just.
No, I can hear you, but if I turn my mute off, I can't hear you.
No, we're just asking you to mute your phone. Can you not hear us through the microphone, through the? If you would like to speak, you can unmute your phone. If you would like to speak, unmute your phone, but we are getting some background noise.
No, because there's all these.
Yeah, it's, how's that now?
That's
fine.
good.
Okay,
I
perfect.
can't hear you. Let me go back up here and see if I can. Can you hear me through the audio on my computer now?
I can hear you now.
Yes, we can hear you. Can you hear us?
I can't hear you. Just a second here. Okay, there we are.
Okay.
Guess we're back online.
No, we've got feedback now. Yeah, sorry.
Okay. You know what? So, Madam Clerk, could you read the motion for 12, please?
The motion for 12 was already read.
Okay.
Yep. If you can just call the vote.
Yep. All in favor? That is carried. And now we're at reports, announcements of members of council. Does anyone have anything to report or announce at this time? Yeah. Okay. Councillor Young first.
Thank you, Lori and Mayor. I just want to indicate as a member of the police board, there's a couple things happening. One of them is that we're being charged by the OPP for calls made. And I sort of got into it with the OPP, and I say get into it, just asking questions about that. And I requested that they define exactly what that means, because as I found out, we're not charged for every call that comes in, and the attending OPP officers weren't quite sure as well how that's defined. So, because every time we're charged, every time a call comes in, as you know, we're charged, and for it. And the bigger picture is to try and reduce the police budget. So that's being addressed. The second thing is a policy they have in place, or a program they have in place, wherein cameras that are in residences or businesses are registered with the OPP. And when I say registered, the OPP cannot have access to it. It's not in that way. It's just that you've indicated, the OPP, that you have a camera in your residence. It's a course. It leads or provides evidence of as to the culprits or the bad guys or the suspects if there's a crime committed. I'll tell you, and it's a good program, and it's going to be put on the Oro-Medonte website there with all the information and the where you can call in and register your cameras or camera. And again, they don't have any access to it. You have to consent if they want to have a look. And I just tell you the importance of that recent $6 million fire in Aurelia was it was defined, or at least it was, the suspect was apprehended or arrested through the cameras that in the downtown area, $6 million fire, and they were able to determine within a day or two who did it. Excuse me. So, excuse me. In terms of Moonstone area, several weeks ago there was a number of cars, not familiar cars, that kept somewhat cruising the area, and the citizens up there, the residents, were concerned about it. But as it turned out, it was the OPP, excuse me, in plain door units. But had it not been, and the purpose of that car or cars cruising the area was to commit a crime, they quite likely would have had video of the type of car that was involved. So that's what's going on right now, and I'll let you know about the programs.
Okay. Thank you very much, Councillor Young. Councillor Hutchison.
Thank you, Mayor Greenlaw. Just a reminder that Family Day weekend, Family Day is on Monday, and Sweetwater Park is having their cardboard toboggan races. And I also read an interesting article that this Saturday is Flag Day in Canada, and it's the 60th anniversary of the Maple Leaf flag, and that 5 former prime ministers are encouraging Canadians to fly a Canadian flag on Flag Day, just in solidarity of our nation and what's happening south of the border. So if you've got one, fly it on Saturday.
Thank you very much. Councillor Bard.
Thank you, Mr. Mayor. Just to let people know that this weekend is the 4th annual Braystone Winter Classic. It's a 3-on-3 charity pond hockey tournament in support of the Hudson Regional Cancer Center at RVH. So it's on Sunday, the 16th. The goal this year is to raise $155,000, and at this point on their meter they're at $152,864, which is truly amazing. So 99% of their goal. You can, if you can't attend, you can go to their webpage and there is a click to donate button, and maybe you'd be the person to get them over the goal. So it's a great event, and wish them all the best.
Yep, great. Thank you very much. Councillor Clark.
Thank you, Mr. Mayor. Just an announcement as well from the Lions Club that they have a family skates at the Oro Community Arena from 10:30 to noon, so all are welcome. So free skating for kids of all ages, hot chocolate, cookies, and coffee, and it's a great on Monday, February 17th, 10:30 to noon at the Oro Community Arena, otherwise sometimes known as the Guthrie Arena.
Thank you. Is there anyone else? Seeing, I just want to take a moment to recognize February's Black History Month, which is the time to honor and celebrate the rich heritage, achievements, and contributions of Black individuals throughout history. And it's also time to reflect on the struggles and triumphs that have shaped the Black community and recognize the profound impact they have on society. The legacy of the early Black settlers in our township is woven into the fabric of Oro-Medonte. Their contributions laid the foundation of an inclusive and diverse community. The Black community in Oro-Medonte were pioneers who faced and overcame numerous challenges. They built homes, cultivated the land, and established vibrant communities that included the Oro African Church, which has become a National Historic Site. If you haven't been to the church, it is located at the corner of Line 3 North and Old Barry Road, and I encourage everyone to visit. Also, for anyone interested, there will be a lunch and learn at the Pie Education Center in Barrie on February 26th, where Doug Minter from the Oro Freedom Institute will be speaking. It is called the Canadian Black History Story. That is one that you've probably never heard before. So I do want to take a moment and hope everyone recognizes the importance of this month and the recognition to the Black community. Any other announcements, comments, or reports from partners and agencies? Seeing none, Madam Clerk, well, does anyone want anything moved from the consent agenda? Seeing, no, so may we have a motion to receive the consent agenda, please?
Moved by Shell, seconded by Hutchison. Be it resolved that the staff recommendations with respect to the items listed under consent agenda correspondence be adopted as printed.
Thank you very much. I'll call the vote. All in favor? That is carried. We're now, I just want to make sure because we're jumping around a bit, but so we're now on 15B. May we have a motion for item 15B, Madam Clerk?
Moved by Shell, seconded by Bard. Be it resolved that the correspondence dated January 25th, 2025 from Ryan Trudeau, citizen, Barrie South Simcoe Métis Council, citizen Métis Nation of Ontario, Simcoe County and Region 7 resident. Request to waive boat ramp and parking fees. Métis Nation of Ontario access to Lake Simcoe in Oro-Medonte be received, that the request be referred to staff for a report back to council.
No, thank you. So just to bring clarity so that we're not passing this, we're referring it to staff. So I did ask for some mapping and stuff. The mapping doesn't really give us an indication of where Area 7 or Zone 7 is, and it doesn't encompass doesn't show Lake Simcoe on it. So it shows Georgian Bay. So I think there's some things we need to get clarity on before we pass this, and hopefully it comes back and we can move forward. Okay? So you've heard the motion. I'll call the vote. All in favor? That has passed. And notice of motions, there are none. May we have the motion for the draft bylaws under item 17, Madam Clerk?
Moved by Clark, seconded by Hutchison. Be it resolved that bylaws number 2025-008 and 2025-019 be read a first, second, and third time, passed, being engrossed by the clerk, signed and sealed by the mayor.
Okay. Any comments or questions regarding the draft bylaws? Yes. Councillor Hutchison, you'd like to speak?
Yep, sure. Just a quick, thank you, through you, Mayor Greenlaw. Just a quick comment on the designation of Carly Hall. This has been a lot of hard work for the Heritage Committee in identifying potential heritage buildings within the township. We are under some time requirement from the provincial government to identify and to move through the process. So I was very pleased to see that we've been able to get to this stage with Carly Hall. It's one of our, we've got a number of halls, but I would say it's the most unique, and it's still in very much its original condition. And I think it's a real, just a very nice step forward for the Heritage Committee and identification of this. So thank you.
Yeah.
It is a gem.
No.
Yes.
No, it is. It is a beautiful building. And I echo your comments because the Heritage Committee has put a lot of time and work into this, and it's great to see this get moved along. Thank you. Okay. Any other comments or questions? If not, then I'll call the vote. All in favor? That is carried. May we have a motion for the confirmation bylaw, Madam Clerk?
Moved by Shell, seconded by Bard. Be it resolved that bylaw number 2025-020, being a bylaw to confirm the proceedings of the council meeting held on Wednesday, February 12th, 2025, be read a first, second, and third time, passed, being engrossed by the clerk, signed and sealed by the mayor.
Yeah, we did them together. Yeah. I just, the deputy wanted to make sure we did 17B, but I said we did bylaws together.
Yes.
Right, okay, so thank you. Okay, so I'll call the vote. All in favor? That is cleared or carried. Cleared's not the right word, my apologies. Yes. May we have a motion to adjourn, Madam Clerk?
Moved by Young, seconded by Lavoie. Be it resolved that we do now adjourn at 5:30 p.m.
All in favor? That is carried, and everyone have safe travels tonight and tomorrow, as I know we're getting a lot of snow this weekend. And have an amazing Family Day weekend. Get out to Braystone and to Sugar Bush on Monday. Okay? Take care.
Thank you.